Paddling UG VCA. Facts. On November 17, 1982, the Sangguniang Panlungsod of Davao City enacted Ordinance No. 363, Series of 1982, otherwise known as the Expanded Zoning Ordinance of Davao City. Petitioner was able to obtain a building permit for the construction of a funeral parlor. Thereafter, petitioner commenced the construction of his funeral parlor. Acting on the complaint of several residents of Barangay Igdao, Davao City, that the construction of petitioner's funeral parlor violated Ordinance No. 363, since it was allegedly situated within a 50-meter radius from the Iglesia ni Cristo Chapel and several residential structures. The nearest residential structure, owned by Wilfred G. Tiput, is only 8 inches to the south. Private respondents filed a case for the declaration of nullity of the building permit. After conducting an inspection, the court dismissed the complaint, holding that the chapel is 55.95 meters away from the funeral parlor and the building owned by Mr. Tiput is being rented to Mr. Ajiatan, who devotes said place to his laundry business. On appeal, the CA reversed. It disagreed with the lower court's determination that Tiput's building was commercial and ruled that although it was used by Mr. Tiput's lessee for laundry business, it was a residential lot as reflected in the tax declaration, thus paving the way for the application of Ordinance No. 363. Issue 1. Petitioner's operation of a funeral home constitutes permissible use within a particular district or zone in Davao City. Held yes. Ratio. In the case at bar, the testimony of City Councilor Vergara shows that Mr. Tiput's building was used for a dual purpose, both as a dwelling and as a place where a laundry business was conducted. 8. But while its commercial aspect has been established by the presence of machineries and laundry paraphernalia, its use as a residence, other than being declared for taxation purposes as such, was not fully substantiated. The reversal by the CA of the trial court's decision was based on Tiput's building being declared for taxation purposes as residential. It is our considered view, however, that a tax declaration is not conclusive of the nature of the property for zoning purposes. A property may have been declared by its owner as residential for real estate taxation purposes, but it may well be within a commercial zone. A discrepancy may thus exist in the determination of the nature of property for real estate taxation purposes vis-a-vis the determination of a property for zoning purposes. Needless to say, even if we are to examine the evidentiary value of a tax declaration under the Real Property Tax Code, a tax declaration only enables the assessor to identify the same for assessment levels. In fact, a tax declaration does not bind a provincial/city assessor, for under sections 22 of the Real Estate Tax Code. Appraisal and assessment are based on the actual use irrespective of any previous assessment or taxpayer's valuation thereon, which is based on a taxpayer's declaration. In fact, a piece of land declared by a taxpayer as residential may be assessed by the provincial or city assessor as commercial because its actual use is commercial. The trial court's determination that Mr. Tiput's building is commercial and, therefore, Sector 8 is inapplicable, is strengthened by the fact that the Sangguniang has declared the questioned area as commercial. Consequently, even if Tiput's building was declared for taxation purposes as residential, once a local government has reclassified an area as commercial, that determination for zoning purposes must prevail. While the commercial character of the questioned vicinity has been declared through the ordinance, private respondents have failed to present convincing arguments to substantiate their claim that Cabaguio Ave, where the funeral parlor was constructed, was still a residential zone. Unquestionably, the operation of a funeral parlor constitutes a commercial purpose, as gleaned from Ordinance 363. The declaration of the said area as a commercial zone through a municipal ordinance is an exercise of police power to promote the good order and general welfare of the people in the locality. Corollary thereto, the state, in order to promote the general welfare, may interfere with personal liberty, with property, and with business and occupations. Thus, persons may be subjected to certain kinds of restraints and burdens. In order to secure the general welfare of the state and to this fundamental aim of government, the rights of the individual may be subordinated. The ordinance which regulates the location of funeral homes has been adopted as part of comprehensive zoning plans for the orderly development of the area covered thereunder. Powers of municipal corporations/local governments. 8.1 Police power. Binoy v. Domingo, Supra. Ratio. The police power is a governmental function, an inherent attribute of sovereignty, which was born with civilized government. It is founded largely on the maxims, Secutor tuo et henum non latas and salus populi est supremo lex. Its fundamental purpose is securing the general welfare, comfort, and convenience of the people. Police power is inherent in the state but not in municipal corporations. Before a municipal corporation may exercise such power, there must be a valid delegation of such power by the legislature, which is the repository of the inherent powers of the state. A valid delegation of police power may arise from express delegation, or be inferred from the mere fact of the creation of the municipal corporation, and as a general rule. Municipal corporations may exercise police powers within the fair intent and purpose of their creation, which are reasonably proper to give effect to the powers expressly granted. And statutes conferring powers on public corporations have been construed as empowering them to do the things essential to the enjoyment of life and desirable for the safety of the people. Municipal governments exercise this power under the General Welfare Clause. Pursuant thereto, they are clothed with authority to enact such ordinances and issue such regulations as may be necessary to carry out and discharge the responsibilities conferred upon it by law, and such as shall be necessary and proper to provide for the health, safety, comfort, and convenience, maintain peace and order, improve public morals, promote the prosperity and general welfare of the municipality and the inhabitants thereof, and ensure the protection of property therein. And under Section 7 of BP 337, every local government unit shall exercise the powers expressly granted, those necessarily implied therefrom, as well as powers necessary and proper for governance, such as to promote health and safety, enhance prosperity, improve morals, and maintain peace and order in the local government unit, and preserve the comfort and convenience of the inhabitants therein. Police power is the power to prescribe regulations to promote the health, morals, peace, education, good order, or safety and general welfare of the people. It is the most essential, insistent, and illimitable of powers. In a sense, it is the greatest and most powerful attribute of the government. The police power of a municipal corporation is broad, and has been said to be commensurate with, but not to exceed, the duty to provide for the real needs of the people in their health, safety, comfort, and convenience as consistently as may be with private rights. It extends to all the great public needs, and, in a broad sense, includes all legislation and almost every function of the municipal government. It covers a wide scope of subjects, and, while it is especially occupied with whatever affects the peace, security, health, morals, and general welfare of the community, it is not limited thereto, but is broadened to deal with conditions which exist so as to bring out of them the greatest welfare of the people by promoting public convenience or general prosperity, and to everything worthwhile for the preservation of comfort of the inhabitants of the corporation. Thus, it is deemed inadvisable to attempt to frame any definition which shall absolutely indicate the limits of police power.